Today, we're diving deep into the advanced layers of disclosure and privilege in litigation, covering everything from pre-action and third-party disclosure to privilege logs, judicial inspection, and the critical issue of loss of privilege. We'll compare how these crucial steps play out across the UK, US, EU, and beyond, revealing not just the theory, but the real-world impact on cases from competition law to corporate disputes. Whether you're a solicitor, barrister, legal executive, or compliance professional, mastering these tools is essential for ensuring fairness, transparency, and justice in any legal system. So let's unlock the secrets behind the documents that can make or break a case. Pre-action disclosure is a valuable tool in litigation, allowing parties to obtain crucial evidence before formal proceedings begin. In jurisdictions like the UK, Canada, and Australia, pre-action disclosure is possible if it is necessary and proportionate, helping parties clarify issues and possibly resolve disputes early. The US system allows for early discovery in certain cases, particularly when evidence may be lost or when urgent intervention is needed. In contrast, the EU generally restricts pre-action disclosure, though it may be permitted in specific contexts, such as competition law. This comparative approach shows how pre-action disclosure can either streamline disputes or remain tightly controlled, balancing the need for early access to evidence against the risks of fishing expeditions. Third-party disclosure empowers courts to compel individuals or entities not directly involved in a lawsuit to produce relevant documents or evidence. In the UK, Canada, and Australia, courts can order non-parties to disclose documents when it is necessary for the fair resolution of the case. The U.S. system relies on the subpoena process, which enables parties to directly require non-parties to produce evidence or testify. In the EU, third-party disclosure is rare and typically only allowed in exceptional circumstances, reflecting a more restrictive approach. These differences underscore how various legal systems balance the pursuit of evidence with the protection of outsiders from unnecessary involvement in litigation. A privilege log is a crucial tool in legal discovery, ensuring transparency when documents are withheld on grounds of legal privilege. In jurisdictions like the UK and US, parties are required to identify and describe the nature of withheld documents, providing enough detail for the opposing side to assess the claim of privilege without revealing the protected content. Australia and Canada also often require privilege logs to promote fair play in litigation. In contrast, the EU tends to focus more on the duty of secrecy rather than formal privilege logs, making detailed disclosure less common. These different practices reflect each system's approach to balancing privacy, fairness, and efficiency in the discovery process. Judicial inspection, often known as in-camera review, is a process where a judge privately examines documents to determine whether they are protected by privilege before they can be disclosed in litigation. This safeguard is commonly employed in the UK and US whenever privilege is disputed, ensuring that only appropriate materials are withheld. Australia and Canada also allow for in-camera review, providing courts with a direct way to resolve privilege disagreements. In the EU, judicial inspection is rare and typically limited to criminal proceedings. Overall, judicial inspection serves as a critical tool in balancing parties' rights to evidence with the need to protect confidential or privileged information. Legal discovery practices around the world include several important concepts that shape how information is shared. Loss of privilege occurs when protection over confidential communications is waived, breached, or falls within the crime-fraud exception, a principle recognized in the UK, US, Australia, and Canada, though the EU focuses more on breaches of secrecy. The cards-on-the-table approach, prevalent in the UK and US, encourages full transparency and good faith disclosure to promote fairness. This is echoed in Australia and Canada, but is not a formal doctrine in the EU. Lastly, sampling or sequential disclosure helps manage large volumes of data, especially in e-discovery, by allowing partial review and disclosure to reduce burdens and costs. This method is common in the UK, US, Australia, and Canada, but rare in the EU.